protecting a young person's privacy and confidentiality. If you work with young people, another duty you have is to protect their privacy and confidentiality. This is an ethical obligation as well as a legal requirement if you or your agency handle a young person's personal information. As a youth worker, you can be faced with many situations where you will have to make a decision as to whether or not to disclose information a client has told you. Knowing what information you can and cannot disclose is important. Consider the following scenario. A young person, Ruby, tells Nathan, her youth worker, that she has moved out of home because she's had a falling out with her parents. She tells Nathan she's now sleeping on a friend's couch. Ruby's mother calls the youth centre and asks to speak to Nathan because she found his phone number written down on a card in Ruby's old room. Ruby's mother tells Nathan she's frantic with worry because she hasn't spoken to Ruby since Ruby left. Ruby's mother says she just wants to know where Ruby is living so she knows she is safe. What should Nathan do? If you work with young people, you may hold personal information about them that is protected by privacy laws. Under privacy laws, personal information can include a young person's name, address, date of birth and gender, things a young person tells you about themselves, things other people tell you about the young person, for example, information contained in a doctor's report, the fact that a young person is or was a client of your agency, things that happen involving the young person at your agency, for example, if they were involved in a fight, things you observe about a young person, for example, their behaviour, your professional judgments or opinions about the young person, physical information like photographs or drawings of the young person, personal information recorded in any form, whether it's in a client file, on paper, on a computer or even stored in your head, is protected by privacy laws. You should only collect personal information about a young person if it's necessary to carrying out the functions or activities of your service. Some personal information is considered particularly sensitive, like a person's race, ethnicity, religion, criminal records, sexuality or health information. You must not collect that sort of information unless a person consents. Generally speaking, you cannot use or disclose personal information about a young person if it's for a purpose other than carrying out the activities or functions of your service. You must not share that personal information with third parties outside your service unless you have the young person's consent, or the young person would reasonably expect you to use or disclose the information in that way. Other situations where you may be allowed to disclose or share personal information include if you reasonably suspect unlawful activities taking place, or if disclosure is necessary to prevent serious threats to someone's life, health or safety, or if you are required by law. Nathan has personal information about Ruby, which includes where she is living and what Ruby has told him about her living situation. Nathan must take all reasonable steps to keep that information confidential, even from parents or others who might contact him demanding to know this information. Frequently asked questions. When must you destroy records that contain personal information? Your organisation must take all reasonable steps to destroy or de-identify any personal information that's no longer needed. However, you should check first whether your agency or profession has specific time limits on keeping documents, for example, if it's part of a legal service or a health service. If you have personal information which you no longer need, you should shred it instead of simply placing it in the recycling bin. It is important to note that destroying information does not only mean information recorded on paper. Tapes and computer files must also be destroyed. Are photographs of young people covered by privacy laws? It's important to know that personal information includes images as well as words. You should obtain the informed and voluntary consent of the young person before taking their photograph, and again if you want to use it in a newsletter, brochure or website. Consent can be given by the young person verbally, but it's best practice to use a written consent form that is signed and can be kept on file. You must get consent to take or use a photograph of a young person if it's attached or connected with a service that clearly discloses information about the young person's health condition. For example, if the photograph is used for a promotion for a drug counselling service or a mental health support service. Young people of any age can give their own consent if they understand the issues involved. If they do not understand, you should consider getting a parent or guardian to give their consent. If a client requests that photographs of them should not be used in any way, you must take all reasonable steps to respect their wishes and protect their privacy. A young person can also withdraw their consent at any time to have their photographs published in future. If this happens, you must remove the images immediately. You should also be aware that there are some children and young people who should not be identified in any publications, either by photographs or by name. For example, children who are involved in family court proceedings or family violence proceedings, or children who are subject to children's court proceedings in the family division or subject to a protective order of the children's court. Are there situations where I'm allowed to disclose personal information about a young person? The Department of Human Services may require you to disclose information about a young person who is subject to a protection order and comes under state care. There are also special provisions around reporting child abuse or child neglect. For some professionals who work with young people, they are mandated by law to make a report if they have concerns a child is in need of protection from physical injury or sexual abuse in the home. We will be discussing mandatory reporting next.